Good morning and welcome to the series of legal aspects of medical practice. My dear friends, as you know, in olden days doctors were considered as a god and they were a subject of worship. But nowadays, due to the changing norms of the society, the expectation from the doctor by the patients are rising day by day. Also, there are some changing norms of the doctors themselves, and there is easy availability of information and technology. So, patient can search anything from the Google or any other social media. So, information is too much available for the patient. So, as a result of that, doctors are considered as a soft target, and there are so many litigations are filed against the doctors nowadays. So, these litigations can be filed as a criminal case in court of law, but the majority of the cases are filed for the compensation consumer forum. So, after 2019 amendment, it was widely circulated by the message in social media that the definition of the service does not include the healthcare professionals or medical field. Therefore, doctors are now not included under the Consumer Protection Act. But my dear friends, is it true? Of course, we will discuss in this topic and then you will find the answer whether it is true or not. So, as you know, Consumer Protection Act was enacted in 1986. At that time also, there was a lot of confusion regarding the applicability of the Consumer Protection Act to the healthcare professional, to the medical professional, or whether the doctors are covered under Consumer Protection Act 1986 or not. But it was the Supreme Court who made it very clear in 1995 in the Shanta case that doctors are also included under the Consumer Protection Act, and Consumer Protection Act is also applicable to the doctors. So, then why there was some controversy or confusion regarding the applicability of the Consumer Protection Act 2019? My dear friends, if you will go through the definition which is of the service which is given under Consumer Protection Act, it is true that healthcare profession is not specifically mentioned under Consumer Protection Act or under the definition of service under Consumer Protection Act. There are so many fields which are specifically mentioned like lodging, boarding, banking, insurance, etc. But healthcare profession or the doctors or medical profession is not specifically mentioned. But is it true that though it is not specifically mentioned, then it is not covered under Consumer Protection Act or Consumer Protection Act is not applicable to the doctors? No. Why not? Because if you will proceed or if you will read this definition very carefully, there is one word or there are it has been mentioned that includes but not limited to. So what do you mean by include but not limited to? That means Consumer Protection Act 2019 is applicable to the services, or it includes the services which are mentioned in this definition, but it is not limited to. That means it is applicable or it can be made applicable to other services which are not mentioned in this definition. So, though healthcare profession or medical profession or doctors are not mentioned or specifically listed in this definition, it is very clear that though include but not limited to. That means doctors can be also included, or Consumer Protection Act is applicable to the services which are not mentioned in this definition. So, all other services which are not mentioned in this definition are unexpressly included under Consumer Protection Act. So, there was rising demand from one side that doctors should be there in Consumer Protection Act, and on the contrary, there was a rising demand from the doctors that they should be excluded because medical science is imperfect science and no one can be 100% accurate. So, doctors should not be included under Consumer Protection Act. This was a demand from the doctors. So, it may be the reason that healthcare profession is not specifically mentioned, but the word includes but not limited. These words have changed the game, and it means that though it has not been specifically mentioned, doctors are also included under Consumer Protection Act. So, if you will go back to some extent and if you will analyze the definitions which was even given in Consumer Protection Act 1986, in that definition also Consumer Protection Act was not healthcare profession was not specifically mentioned under the definition of service under Consumer Protection Act, but it was the Supreme Court which made it very clear in 1995 VP Shanda case that doctors are also included, or healthcare profession is also included under Consumer Protection Act. So Consumer Protection Act is also applicable to the doctors, and if there is any negligence on the part of the doctor can be sued for the medical negligence under Consumer Protection Act, and if found guilty, then doctor has to pay the compensation to the patient. So it is very clear that though it has not been specifically mentioned, or the health care profession is not specifically mentioned under the Consumer Protection Act 2019, doctors are not out of ambit, or doctors are covered under the Consumer Protection Act 2019. Also, when this confusion Bombay High Court, then also Bombay High Court has also made it very clear regarding the applicability of Consumer Protection Act 2019, that doctors are providing the services if we are providing the services for the fees, in lieu of fee. The word is in lieu of fee. That means if you are providing services for the fee, or if you are providing the services and you are taking or you are collecting the fees from the patient, then you are under the ambit of the Consumer Protection Act. That means Consumer Protection Act is applicable to the doctors also. Only those doctors who are not charging the fees cannot be included under Consumer Protection Act. So also, if you will see the definition of the service which is given under Consumer Protection Act, then you can see at the end there are only two exceptions who are not covered under the Consumer Protection Act, or Consumer Protection Act is not applicable to whom. First is those who are providing the services free of charge. As we are the private practitioner, we cannot provide the service free of charge. If you are a government doctor and if you are providing the services free of charge, then only you are, that is totally free, then you are excluded from the Consumer Protection Act. But we are basically private practitioners, so we can't provide the service free of charge, so we are not excluded, or this exception is not for us, so we are under the Consumer Protection Act. Next very important thing is that on the next exception is that the services which are provided under the contract of personal service. So there are two things, one is contract for personal service and another is contract of personal service. So what is contract of personal service? Contract of personal service means the services which are provided or in which there is master servant relationship is included. That means services provided for the master by the servant, or there is employer and employee relationship. So as far as the doctor and patient are concerned, doctors are not an employee and patient is not employer, or patient is not master or doctor is not servant. So of course these services which are provided by us are not included or do not come under the term contract of personal services. So they are not excluded, or in short, we are not out of the ambit of the Consumer Protection Act. We are covered under the Consumer Protection Act, and the services which are provided by the doctors, they are for the time being, or though they are the personal services provided, they are not provided as the master servant relationship. So there is contract for personal services and not the contract of personal services. Doctors are not covered under the exceptions which are given here. So doctors are covered, or the Consumer Protection Act is applicable for the doctors. Now study the provisions or the amendments which are done in Consumer Protection Act 2019. You will find that now even not only doctors are included in the Consumer Protection Act, on the contrary, it is very easy now for the patient to file the case against the doctors, and the cases against the doctors may rise day by day because of the provisions which are given under Consumer Protection Act 2019. Or we can say that Consumer Protection Act 2019 is not only applicable to the doctors, but on the contrary, it is more troublesome for the doctors, because it is very easy for now for the patient to file the complaint against doctor. What are those provisions? First thing is that there is provision for filing the case for e-commerce. Previously e-commerce was not included, though we are not providing e-commerce, but to some extent we are doing online consultation or online services. So these services these services are also included under the Consumer Protection Act. So even if you are doing teleconsultation, then also you are and if there is negligence on your part, then you are liable for the compensation under Consumer Protection Act. Second thing is that it is now not necessary that patient should go to the consumer forum and file the case physically or manually. Patient can file the case even by e-filing, or e-filing is allowed. That means patient can sit at home and file the case online. So, or e-filing is allowed. So, it is very easy for the patient to file the case. Second thing is that it is not necessary that patient should or patient's lawyer should attend every hearing of the case. He can join by video conferencing. So, it is very easy. Even it is good for the doctor. Doctor can also attend by video conferencing, but it is more in favor, or it looks more in favor for the patient. Third thing is that territorial jurisdiction limit. Previously, it was that if you are practicing in the Ratnagiri district and patient is from some another district, Mumbai, Pune, or any other state, then patient has to file the complaint in the consumer forum of Ratnagiri. But nowadays, patient can file the complaint at the consumer forum of his district, or where he resides, or even at his state. So, it is very easy for the patient to file the complaint against the doctor. So, these provisions are not favorable for the doctor. So, these are some provisions which are in favor of the patient and not in the favor of doctor. So, it is very clear, or it is a take home message, that doctors are not excluded. On the contrary, doctors are included. Even the Bombay High Court has made it very clear that doctors have included under the Consumer Protection Act if they are charging the fees for the patient. And if you will look, or if you will go through the provisions or the changes made in the Consumer Protection Act 2009, it is on the contrary, it is very easy for the patient to file the complaints against the doctor, and it is not true that doctors are excluded from the ambit of Consumer Protection Act, as it was circulated in the media since last 2 years. So, in short, Consumer Protection Act 2019 is applicable to the doctor with more stringent provisions, and it is in more favor of the patient. So, this is my take home message for you.